Hello students, in today's class we are going to study about collection of checks. Under this concept we are going to study process of collection of checks, position of collecting banker, statutory protection to the collecting banker, duties of the collecting banker, bouncing of checks and the criminal liability. Who is a collecting banker? If you look into the definition, a banker is under no legal obligation to collect checks and bills on behalf of its customers. Negotiable Instrument Act doesn't define or doesn't specify on the legal obligation for any banker that he must collect checks on customers' behalf. But every modern bank, it is offering it as a service. But every modern bank collects checks and bills on behalf of its customers in order to provide a service to them. This service of collection of checks on behalf of its customers has become an accepted part of bankers' function due to greater uses of crossed checks. All business organizations make payment, receives payment through crossed checks only. Not only business organizations, even at the individual level, always crossed check is a safest method of making and receiving payment, which are payable through a banker only. So when we refer to crossed checks, we have to keep in mind that it is from bank account to the other bank account. The amount is transferred. So it is the safest method of making payment. So this service all the bankers are providing as a service only, but it is not under legal compulsion. When a banker undertakes to collect checks and bills, he is called collecting banker. Now, who is a collecting banker? A banker who undertakes to collect checks and bills is called as a collecting banker. In the process of collecting checks, now banker accepts checks for the payment. In the process of collecting checks, the banker is acting as a holder for the value and also as an agent of the customer. Now, as a collecting banker, as a holder for value, banker becomes a holder for value of a check in following circumstances. What are those circumstances? Where a banker pays the amount of a check drawn on other bank before collection, the collecting banker is treated as a holder for value. Now we have to understand this. Now you are giving a check on a check drawn on another bank. Now banker need not wait, or many a times banker need not wait to transfer the amount from the other banks or receive the amount from the other banks, but it acts as an agent on behalf of you. It collects the amount. The collecting banker is treated as a holder for that value. Now I am repeating, where a banker pays the amount of a check drawn on another bank before collection, the collecting banker is treated as a holder for that value. Where a collecting banker permits the customer to draw the amount of the check paid in, even before it is cleared, he is becoming a holder for the value of the check. Where he receives a check in specific reduction of the amount due from the customer, in that case also banker is acting as a holder for the value. And where the banker has a lien on the check, in that case also banker is acting as a holder for value. Now collecting banker also acts as an agent, not only as a holder for the value, but he is also acting as an agent on behalf of the customer. When the banker undertakes to collect the check of a customer without becoming holder for value or a holder in due course, he acts as a customer's agent. So banker, without becoming a holder for value also, he holds the your check till the collection of the check. collection of the amount. Now banker is acting as a agent. The banker must act with care and diligence in acting as the agent of the customer. Now when the banker is acting as an on behalf of the customer, the banker must act with the care and diligence. All precautions he has to take, all measures he has to take, so that it prevents all sorts of material alterations, or it takes care of all sorts of dishonoring of checks and any other aspects. If he is negligent, he will be liable to the customer. Now banker has to act as an, when banker is acting as an agent, he has to take all precautions, and banker should act in utmost care and diligence. Otherwise banker is answerable and banker is liable to make the or to meet any loss that is incurred by the customer. If he is negligent, he will be liable to the customer for any loss that he may incur. Now what statutory protection the collecting banker is having under Negotiable Instrument Act of Section 131S of Negotiable Instruments Act. A banker may undertake to collect a check either as a holder for value or merely as an agent to the holder. Now banker acts either as a holder for the value or also as an agent to the holder. When a banker acts as an agent, he gets no better title than his customer. If the customer has a defective title, the collecting banker will not get a better title. Now this we have to understand. Now if the banker is acting as an agent, he is getting the better title than his customer. If the title is defective, banker cannot get a better title than the customer. So he will be held liable for conversion to the true owner if he collects a check for his customer having defective title. Now in the previous classes we understood that title has to be mentioned clearly and it should be given clearly, and if any defective title is there, banker has a right to dishonor the check. In that case, when defective title is there, if banker collects money on behalf of the customer, then the banker will have to face the liability. The statute therefore conferred on the collecting bankers special protection against the conversion. Now what is the statutory protection that is available for the collecting banker? Section 131 of the Negotiable Instrument Act provides protection to a collecting banker who receives payment of a cross check or draft on behalf of customers. Now this we have to understand. In what cases Negotiable Instrument Act provided protection to the collecting banker when he receives payment of a cross check. Now always we say cross check is account transfer, from one bank account to other bank account transfer. Now in that case, when the banker is having the received payment of a crossed check, the Negotiable Instrument Act provides protection. According to Section 131 of the Negotiable Instrument Act, a banker who has in good faith and without negligence received payment for a customer of a check crossed generally or specially. General crossing is, as I said, in two transverse lines. It can be deposited in the customer's account and amount can be collected through the account. Now special crossing is you are specifying from which bank or to which bank it has to be credited or it has to be processed through. In that case, here a check crossed generally or specially to himself shall not, in the case of title to the check proves defective, incur any liability to true owner of the check by reason only of having received such payment. Now, collecting banker is given protection under 131 in case collection of crossed checks against forged instruments. Now, see, forged instruments, as we have discussed in previous classes, then customer banker can have will be familiar with the signatures of the customers, and when it is endorsed or when it is forged, then it is to the court of law that has to decide whether it is forged. The good faith, on the good faith of the customer, banker can collect the money, but when it is forged, then banker will have protection from Negotiable Instrument Act. This protection can be claimed provided the banker received payment in good faith without negligence. Without negligence in the sense, banker has taken all precautions. Banker has checked in all material aspects, and he found that it is to be properly made. In that case, in good faith, without negligence, and it is for our customer, and a check crossed generally or specially to himself. Now, Negotiable Instrument Act is providing protection to the banker. When the banker credits the amount as cash before receiving the proceedings, he becomes a holder in value and thus cannot claim protection stated above. Now, try to understand this. When the banker credits the amount as cash before receiving the proceedings, he becomes a holder in value and thus cannot claim protection stated above. Before it is processed, you have already credited the amount. You have already credited, banker has already credited. In that case, you cannot receive or you cannot claim the protection. This was the position in India until 1922, when the following explanation was added to section 131. There is an explanation, amendment or addition made to section 131. Until then, it was 1922, until 1922, it was, if the banker clears or makes the payment, credits the amount before the check is processed, then banker cannot claim. Now, banker can claim. A banker receives payment of a crossed check for a customer within the meaning of this section, notwithstanding that he credits his customer's account with the amount of the check before receiving the payment thereof. From the above explanation, it is clear that the banker need not have any risk even if he credits the amount as cash before receiving the proceeds. Before the check is processed and before receiving the proceeds also, if a banker has credited the amount in the customer's account, banker can claim the protection. A new section 131A was added in 1924, applying the provisions of chapter 14 relating to crossed checks and drafts as well. Unless the collecting banker can claim protection under the above section, he becomes liable. Now, in all other aspects, banker has to take care, in utmost care he has to process the check, and when he has taken all necessary precautions, and when it is crossed check and the amount, he acted as a agent and is also acted as a holder for value in certain cases, then banker can claim protection. Unless the collecting banker can claim protection under the above section, he becomes, when he cannot claim, because, and it means that, and if the above conditions or above circumstances are not covered, and it is beyond that or it is out of that, then banker is liable. Banker cannot claim protection. He becomes liable for conversion when he collects checks belonging to the customer. He will be entitled to protection only under the following circumstances. Try to understand this. The check should have been crossed before it came into his possession. Now, already crossed check you have to receive. He must have received payment in his capacity as agent of the customer and not in the capacity of a holder. He must have received payment in his capacity as an agent of the customer, not as a holder as a capacity of the holder. Now check should have been crossed before it came to the banker, and the banker received payment in his capacity as an agent but not as a holder for the value. He must have received payment only for the existing customer. He must have acted in good faith and without negligence. The onus of proving the absence of negligence rests on the banker. Now what are the duties of collecting banker? Now what is the protection that the banker has for the payment, or collecting banker has for making the or collecting payment for the customer. Now what duties collecting banker has? Examination of checks and endorsement. You have to examine, a banker has to examine the checks for all proper reasons, like the date and the signatures, and whether it is crossed, whether title is clear, whether it is a properly made check, whether any material alterations are made. So in all these things, whether endorsement is done properly, so whether endorsement is genuine, in all these cases banker has to examine the check for its genuinity, for its good faith. Now presentment of checks for collection. When it says presentment of checks, in previous classes also we understood that the banker or the customer can present the check after the date mentioned within 6 months in certain conditions, and within 3 months in certain, it depends upon the bank rule that within how many months you can present the check, and also it has to be done within the banking hours, and it has to be properly made. It has to be presented before the expiry date or lapse date. Some cases it is 3 months, in some cases it is 6 months, and also it has to be presented within the banking hours. Information to the customer about the collection. Now these days we are getting all kind of messages, whether your check went for collection, whether the amount is credited, so including the time also is mentioned in the message. So it is the duty of the banker to intimate about the collection. Now serve notice of dishonor. In case if you are dishonoring any checks, in all other circumstances, when the check is dishonored and that intimation is received by the banker, banker's bound duty is to intimate the same to the customer. So you have to serve notice of dishonor to the customer. Now precautions to avoid conversion charge, as we discussed in the earlier. Now when as a holder you are acting, or as an agent you are acting, but in all good faith and with all precautions you have taken, and you are not negligent about it, so you have to avoid all conversion charge. You have to, as a banker, you should act as an agent or can act as an holder, but in all material aspects you have to see that you are avoiding all risk which lead to the charges, legal charges. Now another important aspect, when do we call a check is bouncing of check. Now we understood, for making a payment we dishonor check. We dishonor check in case of making a payment. Now when check is bounced, the customer of a bank has to issue checks in favor of third party only when there is adequate balance in his account. Now before we issue a check, we have to be confident. We should know whether the sufficient balance is available in the bank account or not. Now if the sufficient balance is not available in the bank account, you cannot issue a check for a third party. Now in that case, what you have to do, now customer, suppose you have issued a check and the check went for collection, but then you can intimate the banker about not making a payment, stop payment. but in all other aspects, that stop making payment can be done only in certain cases. But for lack of funds in your account, lack of sufficient funds, you cannot give a check to the third party. So the customer of a bank has to issue checks in favor of third party only when there is adequate balance in his account. What happens when you don't have sufficient balance? The check is dishonored. Check will be bounced. We call it bouncing of check. The making of payment is refused. In that case, it leads to legal charge. The check will be dishonored in the absence of sufficient balance in the account. This is called bouncing of check. Consequences. What happens when the check is bounced? Consequences of bouncing of check. Up to March 31st, 1989, the drawer of such bounced checks is subject to civil liability only. Now this we should understand. Till 1989, the Negotiable Instrument Act says if the check is bounced, the drawer, the one who has drawn the check, is having only civil liability. Okay, only in case of dishonoring of the check. Now this, because it is civil liability, people were not taking it seriously, and so there were large number of cases bouncing. There were large number of cases bouncing, and so certain amendments were made to the Negotiable Instrument Act. Civil cases take too long time, as we all know. To settle a civil case, it is not, it takes a long time, but this is at the other end, the person who has to receive money, and it is his right to receive money, and the check is dishonored and it went to civil court, and it is a civil case, and if the money is not settled, and it leads to a lot of inconvenience to the receiver, and hence the government therefore has inserted chapter 17 containing section 138 to 142 to the Negotiable Instrument Act of 1881. So these sections made dishonor of a check. Now this we have to make note. Now this is a criminal offense. Now dishonoring of check is a criminal offense. Earlier it was civil. Now civil, because people are not taking it seriously, and the government had to take a decision on that and made negotiable amendment to the Negotiable Instrument Act, and chapter 17 is included, and sections from 138 to 142 discusses about what all the criminal consequences the bouncing of check will have. These sections made dishonor of a check a criminal offense with effect from April 1st, 1989. Now, the changes in the Negotiable Instrument Act were brought through banking, public financial institutions, and Negotiable Instrument Laws Amendment Act of 1988. Now, the changes make dishonor of check due to insufficiency of funds. Now, in previous class, previous topic, we understood that when you have sufficient funds only, you have to issue check. Knowing that you don't have sufficient funds, and when you are not confident that you can arrange funds, even then if you are issuing a check, then it is a criminal offense. The changes make dishonor of a check due to insufficiency of funds as a criminal offense on the part of issuer, and the drawer may be punished with imprisonment for a term which may be extended to 2 years, or with fine up to twice the amount of the check, or with both. Now see the severe consequences of issuing a check when you have insufficient funds. Now this is a criminal offense. It is not a normal mistake. It is not a normal mistake that people will take a long period of time to settle the issue. No, it is a criminal offense. Now what a Negotiable Instrument Act says and what consequences, punishment it gives is, it is a criminal offense. The drawer may be punished with imprisonment. You can be put in jail if you issue a check when you don't have sufficient funds for a term which may be extended to 2 years. Maximum limit is 2 years, or with a fine up to twice the amount of the check, or with both. Now every punishment, either it is a imprisonment and also it is up the fine up to the twice of the amount. Suppose you have to pay some 10 lakh rupees, you issued a check and then it got bounced. Now the double the amount means 20 lakh rupees you have to pay along with the imprisonment, check or with both. Okay, it is again, it is at the discretion and it is at the court of law to decide to what amount will be the fine, but it will extend up to twice of the amount that you have to make the payment. Now such punishment is in addition to his liability in civil suit. Now this is one more thing we have to remember. Now this is not stopping only at the civil liability. Civil liability plus criminal liability. That criminal liability says to a maximum time of 2 years you can be put in jail, and also maximum to twice of the amount that you have to make payment will be your monetary fine that you have to make payment. Okay, then what is criminal liability? Other criminal liability. The following aspects are covered under chapter 17 of the Act for fixing criminal liability. The check has been issued in discharge or a debt or other liability in whole or in part. The check has been issued in discharge or a debt or other liability in totality or as a part. The check has been presented to the paying banker within a period of 6 months from the date on which it is drawn or within a period of its validity which is earlier. Now we certain banks, some banks they follow 3 months period of validity, some banks follow 6 months period of validity for presentation of check. But you have to, as a customer, you should know that you have sufficient funds and you should check, and the check should be presented to the whomever you are giving the check. Intimate that person the before which date he has to go for the request for making the payment. The check has been presented to the paying banker within a period of 6 months from the date on which it is drawn or within a period of its validity which is earlier. The dishonor of check should be on account of insufficiency of funds. Now only we are covering the dishonor of this check only for inadequacy, insufficiency of funds. Now let us try to understand this. Now check for a reason of inadequate funds, if it is bounced, it is treated as criminal liability along with the civil suit. Criminal liability extended to maximum limit of 2 years of imprisonment plus twice the amount of your debt. And it also includes the civil suit, whatever is the punishment that you have to take. Now the payee or the holder in due course. Who is payee? The person who has to receive the amount is payee. Payee or holder in due course should give notice in writing to the drawer demanding payment within 15 days. Now this is another leverage that the drawer has. Now the check is bounced. Now it is not immediately we will go fight with them, we will go suit against them. Now we can give time to the person at 15 days time. This is the Negotiable Instrument Act says you can give up to within 15 days of his receiving information regarding the dishonor. Now I have issued check and my account doesn't have sufficient funds, so the check is dishonored. Banker will intimate that your check is dishonored. Now what I should do? Immediately I should approach the person, then I should request the person that I will make a payment within 15 days, and the payee or the holder in due course should give notice in writing to the drawer. Now the person will come, payee also will come to me or can tell me or can give me notice that the amount should be paid, make a payment within 15 days of the receiving of information regarding the dishonor. The drawer can make payment within 15 days of the receipt of the notice, failing which prosecution can take place. So another 15 days, not the time. See, the check is given and within 3 months or 6 months Now after that also some 15 days time is given. Now this is a willful fraud we can call. Now it is intentionally done. Now you have not made the sufficient funds, or whatever is the amount that you have to make payment, you have to arrange the funds, and you have not arranged the funds and the check got dishonored, and it is your bound duty to make arrangement for the payment of amount within 15 days, failing which you are attracting the prosecution. The complaint can be made within 1 month of the cause of action arising. No court lower than the Metropolitan Magistrate or Judicial Magistrate of first class can try the offence. No, not that you can go to any other court, or it is no court lower than, it is specified, lower than the Metropolitan Magistrate or Judicial Magistrate of first class can try the offence. Now we should understand that collecting banker can act as an holder, collecting banker can act as an agent. Now collecting banker, after taking all necessary precautions, proving that he has not being negligent and he has taken all necessary care to present the check on behalf of the customer, even then if the amount is not credited and the check is dishonored and the collecting banker is protected under the statutory law, Negotiable Instrument Act, he has protection. Now the dishonoring of checks, in case of willful dishonor of the check for insufficiency of funds, you are attracting criminal liability. Hope you understood this concept of collecting banker. Thank you.